Well, thank you guys for making it to our presentation today. With me, I have Jerry Reihsen. He's a business consultant and securities attorney. And this is going to be a pretty interesting presentation, I think. So I'm excited. I'll go ahead and turn it over to you, Jerry.
All right, so everybody can hear me fine? I'm usually told I don't need a microphone, so we'll see. So, look, I was in a really unique area of real estate investment funds. They were called non-listed REITs, and they didn't really exist until about 2000. And we started our company in 2000. And for years, first year, the whole industry raised a few $100 million. And then next year it raised a couple of billion. And the next year it raised $6 billion, then $8 billion, then $20 billion, and we kind of went with the wave. By the time we were raising more than $10 billion a year, we came to the attention of people who know how to use litigation to extract cash out of you. That's ultimately what's happening, what's about to happen in this space. It's happening now already. So it's not so much, and by the way, these were fully registered public offerings, non-listed REITs, that you could sell to anybody. And we raised more than $5.5 billion in my company with my three partners at $27,000 per investment. So we had hundreds of thousands of investors. And we never had a successful lawsuit against us. In fact, most of them got killed at or before summary judgment. But we had lawsuits. And if we didn't do everything just right, in other words, if I hadn't been drafting the prospectuses, we would have lost some of them, right? Anyway, so that's that's where we're looking right now in this space. It's a fabulous space, just like non-listed REIT. So a very inventive way to do a real estate fund in a public wrapper that isn't trading, but it's still an illiquid real estate fund. Just as an aside, and I can't take too many of these, or I'm not going to get through this. My prior business in that regard was a business with almost no liquidity and lots of fundamentals. That's what real estate is, right? Operating dynamics and stuff. Blockchain cryptocurrency is almost no fundamentals and lots of liquidity. So it's kind of interesting that now I've morphed into this space. All right, this slide, read it all right away. I'm not your lawyer. Nothing I say can be held against me, and it might be total bullshit. So you have to take it with a grain of salt. Every person's legal situation is different. So I've categorized the litigation to date, and I've done it pursuant to the bulk, the larger bulk first, and the smaller bulk second. The biggest area of litigation, as far as numerosity of it goes, is the out-and-out scams. Who can tell me how you do magic? What is the basic premise of magic? Sleight of hand, right? It's getting somebody's attention to something, and then it's the same with pickpocketing. You touch people in a bunch of places, you bump them, and then when their sensory dynamics are over here, you don't even have to be subtle. Just take the wallet right out. The problem, one of the big problems with cryptocurrency is that there's plenty of ways to make your mind all screwed up, and then you get deceived. And so you're seeing a lot of these cases. The first, 2014, brought by the SEC. By the way, this is a huge waste of time for the SEC, right? They should be dealing with trying to create an effective securities market and effective offerings of these new types of financial instruments. Instead, since the states, frankly, which really should be prosecuting out-and-out fraud, are just laying down on the job, doing their 9 to 5, they have to come in and deal with this, and they haven't been able to then dedicate the time to guide the market. So the leader in the space has been the SEC. I'm not going to say much. Ponzi schemes and pyramid schemes exhaust themselves pretty quickly. So my basic advice is don't do it. It's the ultimate in short-termism. It's not really, if you expect to live longer than 6 months and you don't want to be in jail and frankly have any ethics, don't do it. The next, again, the same thing. The next leading regulator prosecuting Ponzi and pyramid and other scams is the CFTC. Again, a total waste of their time in what the state should be doing when they should be creating good markets in the commodity side of the space. The CFTC actually does not govern commodities, believe it or not, with one exception. They govern commodities futures, not commodities. with one exception that a few years ago got folded in. They can deal in fraud in basic commodities, and that's why they're having to do this. Total waste of time, except that somebody's going to do it. FTC also having to step in. Now, the FTC is a little more appropriate because it's all about consumer protection. So they're bringing these cases as well. And the states, I'm from Dallas, by the way, so I'm kind of proud to say that at least Dallas has a couple of efforts to do something about it. Most of the other states have none at all, and a few have one or two. So, by the way, this one is really interesting, and I'll talk about it again later. This was brought by the Massachusetts Securities Commission, so it's a kind of a repeat of the SEC. And what they basically said is something that is really important for people doing ICOs to know. If you think you're going to comply by excluding U.S. citizens in some kind of IP address prohibition or whatever, you can't rely on that. If a U.S. citizen can get a token at all, the whole offering is going to be regulated by the U.S. securities laws, and that's what this stood for. The guy tried, right, and the Massachusetts Securities Commission said, "Hey, we don't care. A U.S. citizen got it." So for all these people who think trying, think of Yoda or think of whatever the Karate Kid. Do not try. Do. Anyway, next largest area of litigation, and it's kind of in order of how easy it is to do the litigation, is, and I forgot to start my timer. Oh well, he's going to sue me. Is in bank secrecy, money laundering, that kind of stuff. It's because it's very easy to bring these cases. And again, you have multiple layers of regulators in this space. You have FinCEN at the federal layer, and you have every state has a money services business. And by the way, in the third world, they have money services business called mobile money legislation, mobile money businesses, MMB, because they skipped, the Western Union wiring dynamic, and they do everything on their phones. So theirs is money. So anyway, if you have a token that transmits value, you're likely to be covered under money services business FinCEN law. And what you have to do, you have to figure out every jurisdiction where that money transfer, that value transfer can occur, and you have to go register with them, and then you have to adopt policies and procedures to make sure that you're complying with the laws, which mostly are around making sure you're not dealing with bad actors, right? Or at least evidencing that you're trying not to. This is one area where trying actually works. If you do policies and procedures and they look valid, a few bad transactions won't necessarily get you. And the interesting thing is it started early on with people doing these meetups where they traded Bitcoin for money back and forth, and that still happens obviously, where persons who were unfamiliar with the space didn't know how to get into it. So there's a line of cases all around that type of dynamic. That type of dynamic is a little safer from regulation because it's so personal, intrastate, inside the state, and every state's money services business law is a little different. So for instance, in Texas, our money services business law, in one tiny exception, doesn't cover cryptocurrency. So you really don't have to register here. And a few other states are like that too. So what you found is some cases that found that that action was covered, and some cases found that action was not. Generally the cases where people were found to be personally liable and guilty and put in jail for violating these laws were cases where they also sold some drugs or something else alongside with it. And then marketplaces is another dynamic around this. Obviously, the Silk Road case is the most notorious of them. So marketplaces are places where value can be exchanged, right? And if you haven't complied with the Know Your Customer and KYC and done your registration, you're going to be put out of business. And then finally, within distributed ledger technology and blockchain business itself, some of the tokens, and you have to do, if you're doing a token dynamic, you have to look at your token closely and see if it's something that does transmit value. Not all tokens are things that transmit value outside of the system that you're setting up. So you don't always have to worry about, like, you always have to worry about it, but you don't always have to do this compliance. But, you know, Ripple's the most famous. Ripple, as you know, started as as not a cryptocurrency, and a lot of people say it's still not a cryptocurrency, but it started as a dynamic using technology to make more efficient currency exchanges, and they, like all good technologists, didn't bother to get good legal counsel. They just did, and I respect that. I respect people who are doers. But they found out that, look, what we're doing is not legal. They paid, I think, a $750,000 fine, which was not all that material. Fortunately for them, they went forward. And they kind of solved the problem by limiting their customers to KYC, AML, registered customers. So they kind of come in underneath, for the most part, and take advantage, which is what I did, actually, when I would sell non-listed REIT securities through the broker-dealer community. I would recruit them to be my AML KYC because they knew their customers, right? They have to. But I also did it myself, just as a double check. What I'm trying to pass on here is what lessons we can learn to date from these things. I didn't put a lessons thing on scams because the only lesson is don't be a scammer. But the lessons here are, unless you're doing a person-to-person dynamic the old-fashioned way, you've got a lot of MSB-type laws to worry about, right? Because a jurisdictionless instrument is actually the opposite of a jurisdictionless instrument, right? It actually touches every jurisdiction instead of none. In the U.S., obviously state and federal. I told you about money, mobile money business laws. I don't want to dissuade anybody, but if you're going to really do a good job just to comply in U.S. and Canada, even with the guys I know who are solo experts in this space, we're talking about a 2-year process and $2 million to get registered everywhere. So, for instance, my pals at CoinSource in Fort Worth who do a Bitcoin kiosk, what they've done is they've kind of built out slowly. They got their FinCEN, and then they do state by state, and they move into each state. So it's an important kind of way to kind of mitigate rather than try to do it all up front. Talked about the massive number. Currently, my belief is there's a way too big overemphasis on securities laws. Certainly it's important, but this is going to catch you up quicker than securities laws, and securities laws does have a criminal potential, but this is explicitly a criminal dynamic. It can be. So I actually think this is the area where you businessmen need to pay attention. And even though it's been the highest area of enforcement besides scams, there's actually, on the whole, a low dynamic of enforcement. So that's why I think people don't pay a lot of attention. Plus, the head of, that's commodities. Commodities is the next one. I talked to you about the fact that commodities only governs futures unless there's fraud. The interesting thing is, and so there's a lot of commodities cases in fraud, but the interesting question around commodities is, can a utility token itself ultimately be a regulated commodities future instrument, right? So if you're buying a token for a future later value, and you haven't complied with the CFTC rules, are you in trouble? And I think especially when my ultimate advice slide comes up, which a lot of people won't like, I think ultimately that throwing a token out in the world at X price with a speculative upside probably is a commodities futures contract. All right, securities. So I've been a securities attorney for more than 30 years, and I have huge respect for the SEC, and I've dealt with a lot of regulators. They're really good people. They're really smart. They really want to be business people. They will spend a few years there, and then they'll want to be out in the business community. So they want to understand business people. They want to work with business people. There's going to be David Hirsch, a friend of mine in the SEC Enforcement Office, is going to speak a couple of sessions later, right? And he's a great guy. But don't confuse great guys with good friends, right? So those people who tell you, oh, we got to go check this with the securities, with the SEC people, don't do it. Just get good legal advice and take your position. Because you check it with the SEC, you put yourself on their radar, and you might get a bad answer. And now how do you go forward if you've got a bad answer, right? When there's room to make, informed, risk-adjusted decisions. Anyway, the Dow has really interesting meaning. The day the Dow came out, I was giving a presentation on securities laws at lunch. At the afternoon, the Dow report came out. It was the exact same two reports. You could put them together, right? But the most important thing about the Dow is, number one, up to that point, you had people who weren't lawyers saying, hey, this isn't regulated. Like if I rob a bank today and I haven't been stopped, I'm not regulated, right? Well, pretty soon you're going to get regulated pretty hard. But in any event, the Dow was the SEC, being reasonable, wanted to say, look, you're regulated. Here's our report on it. Pay attention. What does this mean? It means if you're an investor, you have lower risk investing in ICO securities that came out before the Dow, because the SEC is less likely to pursue enforcement action against those, because they would say, look, this is our notice to the space. On the other hand, post-Dow ICOs carry a risk of regulatory action which can hurt the value of those securities. So if you're in that part of the space where you're investing, that's something to take into account. Munchie is the latest, and what's happening, it's a very long process to create regulations. So the SEC is not bothering to create regulation. It's a couple-year process often, right? Especially in a brand new thing. There's a study, there's a proposal, there's a comment period, there's a reproposal, there's another comment period. So they're not adopting at this point specific regulations around tokens. Frankly, it took them several years to do the regulations around the Jobs Act, and they still screwed up a bunch of it. But in any event, so what they're doing is they're regulating through enforcement. So they're making, when they go to enforce against a company, they're making really explicit lists of where they went wrong to guide people. So that's what they're, the Munchie case came out a little bit ago. A bunch of technologists, oh shoot, I got 10 minutes? A bunch of technologists, and they didn't get legal counsel really, even though they said they did, and they kept calling it an investment throughout, right? Guarantee you call something an investment, you've just made an admission against interest, they call it in the legal field, and you've set yourself up for both regulatory and civil liability. All right. And this is the big bugaboo. The big bugaboo is that there's a distributed enforcement mechanism in the United States of America. And the distributed enforcement mechanism is, let's distribute private rights of action for securities violations to plaintiffs' lawyers, right? So when people say, hey, I'm doing the best I can to comply, so the SEC is going to go after the other guys, I say, well, this is the bear in the woods thing, right? If you and I go out in the woods, and you look like you can run faster than me, so I'm going to say you can run faster than me, and we encounter a bear, I'm the one who gets eaten. Well, guess what? There's the SEC. There's 53 or 4 American local jurisdictions, state and territorial. And there's several 100,000 plaintiff lawyers. So if you and I go in the forest and we encounter several 100,000 plaintiff lawyers, which one of us gets eaten? Yeah. So that's where the real issue is. The real issue is not so much the regulators, but our highly entrepreneurial plaintiffs bar. And it's already started. And by the way, there are private equity firms that specialize in funding class action litigation. So they don't have to just do sweat equity. They can borrow down or take kind of semi-equity in it. So securities over, let me say one thing about everybody. Again, I love technologists. I'm a big technophile. But they go through statutes like the revenue code for taxation or the securities law, and they parse through each word, right? My tax professor in 1983 told me, don't rely on reading the code. Find out what the code means first, and then read it. There's a lot of humanity in there. It's not code like you write code for software. So all these people relying on Howey are totally going to be sorry. Howey is a relatively complex test for a relatively simple time. In a complex world, you're going to get a simpler test. And here's what the test is going to be. Did you get consideration for a token? And does that token have speculative possibilities? I.e., can there be investment intent in the person to whom you issue that token? That's going to be it. And frankly, there are a line of cases that aren't as extensive as Howey that already say that. So it's not like they have to make this up. So that means an airdrop is even a problem, right? There was a line of cases in the 70s or 80s, and this is why it's helpful to have a guy with some experience, because younger attorneys don't know this, where giving away free stock was found to be violating the securities law. Why? Because the consideration you got was relationship, contact information, more value to your other stock, that kind of stuff. All right. So this is because I was an English major, so that's funny to me. Anyway, the other problem is this. Everybody's focused on the 33 Act. The 33 Act is the federal securities law that focuses on issuing securities, right? And how to do that right. The 34 Act is all about fair and honest markets. Well, everybody in this room who deals with cryptocurrency knows it's so far from fairest honest markets in cryptocurrency, it's unbelievable. It's like 1890s stock exchanges, right? There's a great book called The Scarlet Woman of Wall Street. It talks about the Erie Railroad Wars, exactly what's happening in the 1890s, exactly what is happening today. So the problem is no one focuses on this, and it is a real brain damage situation to figure out how tokens fit into the 34 Act. Whether it's the markets for them, whether it's people who have investment funds, whether it's exchanges, it's all brain damage. So it's something else to consider. I want to point out, back again in the 70s, there was a big move to punish lawyers who don't advise their clients well about securities laws. That's just reared its head again. The chairman of the SEC a couple weeks ago basically said, I don't understand what's happened to the securities bar, and get ready for us to go after you. So if you're a lawyer who's done this, this whole space suffers terribly by short-termism, right? You got X and Y firm making tens of millions of dollars today, and they're trading that for billions of dollars of liability. Because when you violate the securities laws, everybody has personal liability. Every director, officer, promoter, and potentially accountants and lawyers. This is just an area I want to say. There's growing litigation in how do you divide up this assets, whether in divorce, bankruptcy, whatever. Kind of interesting. There's growing just basic contract disputes in it, and things are going to evolve in this space. There's cyber issue litigation, and we've seen all of this. Here's the second to last slide, overarching lessons. I probably have mentioned most of this. Jurisdictionless ecosystems equals jurisdiction-full regulation. There's so much duplication of regulation. It's insane. One of the nice things about this space, it reveals that very well. What's really going to have to happen is one investment regulation, whether it's for franchises, multi-level marketing, securities, commodities. One regulation, get rid of the states, create better exemptions for small-time stuff, and just say, here's the investment opportunity, here's the people behind it, here's their experience, here's the risks, take your chances. So that's the new regulation concept. my advice, and the way I'm advising people to structure it, consider structuring your token environment in tried and true regulatory dynamics. Maybe later it becomes a freely, which might be, for instance, like a reward or a gift card type dynamic, right? Maybe later you free it into the wild, but by that time you've never used it to raise capital, right? For capital's purposes. This is what I call regulatory jujitsu, turning around on them. You also, everybody is focused on where it is today. Back then, there's no regulation. Okay, they're skating to where the puck is. You got to skate to where the puck is going if you want to have any long-term viability. You must combine subject matter innovation with legal innovation. It's hard to find because few lawyers that you're going to find have also run multi-billion-dollar businesses and done it several times like I have. That's what makes you a really good innovator in law. Talked about short-termism. Oh, you see the contract cases? Screwing your contract parties or allowing problems to exist for them, because what do? Almost always devolves back upon yourself. Think about that when you do deals. Is this going to mess up the person I'm doing a deal with? What's their risk? Because their risk becomes my risk. There are already, as I mentioned, law firms filing class actions over ICOs today. There's been about a half a dozen to a dozen, but there's a whole mechanism to ramp that up. And tort reform, which has really contracted the areas where plaintiffs' lawyers can do well, means, wow, once they find this, it's going to explode. Ultimately, either don't use tokens to raise capital or have very strong defenses, which comes to the point I made in the ICO panel. In this area, innovate, guys. Take your risks, take your chances. But remember to develop expertise, because the parties that can really comply with this are global public companies. They already are reporting with respect to their securities. They just have to fold it in. They already have global compliance networks. They have strength and numbers, but they need people who understand the space. So when your business doesn't make it, go talk to Facebook or whoever is doing and looking at a currency. Ultimately, securities token, business operation, so brain, much damage. That's it. Questions? Yes, sir.
So nowadays what is happening is with the security laws, utility token or services related...
It's irrelevant, and it's irrelevant. Utility token analysis is irrelevant. It's only relevant if the relevant thing is, did you raise capital, and is it a token that is freely tradable in the market, so you have upside of speculative intent?
It's a security.
Then it's going to be a security. Yeah.
That's question number one. Yeah. So second question is the other about, I buy BTC on exchange and I send it to somebody in other country, and the transfer is going to be electronic. Is it considered as a
Bitcoin is not a security because it
no,
it didn't benefit any central party, and a personal transaction in it is not regulated.
Not regulated, and as long as I heard that as long as you pay taxes on whatever.
Right. I mean, yeah, you got taxation issues, but it's not regulated in this dynamic.
Oh, thank you.
Yes.
For ICO issues, do firms like you have a methodology whereby the blue sky laws can be followed?
So you cannot comply with securities laws, in my opinion, in this space if you issue a fungible token, a tradable token. I have a dynamic to use a token as an integral and advantage aspect of a business model, which later may become tradable, but you really can't use the token to raise capital. My model uses the tokenization to advantage your attraction to more traditional capital. One more question, I'm told. Yes, sir.
So when the new ICOs are issued and the public buys into it, like you're saying that would be security, right? How does it implies or implicates for the buyers of your token?
So there's there technically could be liability to the buyers, but that's never going to happen. But the buyers could be an underwriter, right? If you attempt to get a security and immediately resell it, or within a short period of time, let's say less than a year or 2 years, you would be like a Wall Street underwriter distributing the security. If you are a whale type, you have significant probability of plaintiff's lawyers getting at you. The SEC is probably not in the States. But if you're just a regular guy, the analysis is all about, should I be buying an ICO given the risk inherent in, again, it's really the plaintiff's lawyers and the likelihood the business is going to be destroyed by a plaintiff's lawsuit. Okay?
Right.
Thank you very much, and I'll be out here afterwards.
Give it up for Jerry Reihsen, everyone. And so we will be back here in 10 minutes. Go ahead, do your thing, and I'll see you in a little bit.